Good, mor- Good morning. My student number is 22021387. I object to the prosecution's attempt to introduce bad character evidence against Mrs. Daenerys, who has been called as a witness for the defense. The prosecution seeks to discredit her credibility based on a prior conviction relating to professional misconduct. However, I submit that this evidence is neither relevant nor admissible under Section 100 of the Criminal Justice Act of 2003. Let us consider the facts of the misconduct in question. Mrs. Daenerys was previously convicted for administering a pharmaceutical drug to a terminally ill patient who was ineligible for any clinical trial. While she accepted responsibility and was fined £2,500, there was no fraudulent intent, no financial dishonesty, and no perjury involved. There was no deception, only unethical lapse. The General Medical Council sanctioned her with a temporary suspension, yet she was permitted to resume her medical practice. The prior conviction has no bearing on the present case under Section 100, subsection 1 of the CGA 2003. Bad character evidence must either provide essential context under subsection A, be directly relevant to an issue under subsection B, or affect the credibility of the witness under subsection C. The conviction fails to meet these criteria. Firstly, the evidence does not provide essential background context as requested by Section 100, subsection 1, subsection A. The case of R versus Davis confirms that bad character evidence should only be admitted when its exclusion would cause substantial difficulty in understanding the facts. Here, Ms. Daenerys' prior conviction adds nothing to the jury's comprehension of the case. Her testimony can be assessed independently, and introducing the evidence would sever no legitimate purpose beyond prejudicing the jury against her. Secondly, the conviction lacks probative value under Section 100, subsection 1, subsection B. The Court of Appeal in R versus Brewster held that bad character evidence must have substantial probative value in assessing credibility. However, Ms. Daenerys' conviction was not deception of fraud. It seemed from an ethical misjudgment, not dishonesty. The case of R versus Henson reinforms the point. A single conviction unrelated to dishonesty does not automatically make a witness unreliable. Thirdly, there is significant risk that the evidence will unfairly prejudice the jury, outweighing any probative value under Section 100, subsection 3. In R versus Y, the courts emphasized the importance of ensuring a fair trial. Allowing the jury to hear this evidence could mislead them into doubting her dishonesty based on an unrelated matter. This would directly undermine the credibility unfairly and breach the principles of Article 6 of European Convention of Human Rights. Article 6 of European Convention of Human Rights, the right is to a fair trial, which includes the presumption of innocence, requires bad character evidence that should not be to create an unfair presumption against a witness. Equality of arms requires evidence that must be relevant and fairly introduced without placing undue weight on past conduct. If Ms. Daenerys' past conviction is admitted, the jury may form an unfair opinion of her credibility before assessing the actual evidence. This could undermine the fairness of the trial, violating her rights under Article 6. The perjurial effect of Ms. Daenerys' past conviction far outweighs any probative value. Case law, including Vi, Henson, Edwards, and Campbell, consistently support excluding such evidence when it risks misleading the jury. The jury may assume dishonesty where none exists, leading to an unfair trial in violation of Article 6 of the ECHR. Firstly, jurors are legal experts that may struggle to distinguish between an ethical lapse and outright dishonesty. In R versus Campbell, the court recognized that jurors may develop an unfair bias when exposed to irrelevant, bad character evidence. This is exactly the risk we face here. An assumption that Ms. Denneries is an untrustworthy witness, when in reality her previous convictions bear no evidence to her truthful worthiness in this case. Regarding the timing of the subsection, it has been filed within the 14-day period as prescribed by the criminal procedure rules. However, in an extension of the time is required, admit that it should be granted due to the complexity of the case. The defense required additional time to assess the impact of this prior conviction, consult legal specialists, and ensure the best possible presentation of our argument. Your Honor, admitting the evidence would not serve the interest of justice. It not provide necessary context. It does not have sufficient probative value, and it would create a serious risk of prejudice. I respectfully urge the court to reject the prosecution's application. Sir, do you have any questions for me?
Under Section 100, Subsection 1 of the Criminal Justice Act 2003, bad character evidence may be admitted if it has substantial probative value. Given the credibility in this case, why should the court not consider Ms. Denarius' past conviction as relevant to her truthfulness?
Good question. Ms. Dennery's conviction for administering an unauthorized drug does not include dishonesty. Under R versus Davis and R versus Y, bad character evidence must be highly relevant to credibility, which this conviction is not. Admitting it risks unfairly tarnishes her truthworthiness.
You say that the prejudicial effect of Ms. Denarius' conviction outweighs its probative value under Section 100, Subsection 3. Could you clarify how the principles in R versus Hansen and R versus Brewster specifically support this claim?
Based on R versus Henson and R versus Brewster, bad character evidence should only be admitted if its probative value outweighs its prejudicial effect. Since Ms. Dennery's conviction does not show a tendency to lie, its admission may unfairly bias the jury.
In R versus Campbell, the court recognized the risk the jurors may struggle to distinguish between ethical lapses and dishonesty. How do you propose that this court ensures that the jury is not misled if we decide to admit this evidence?
In R versus Campbell, the court recognized the danger of jurors equating ethical lapses with dishonesty. If the evidence is admitted, a judicial direction should clarify that the conviction does not imply a lack of truthfulness.
You've cited Article 6 of the ECHR, which guarantees the right to fair trial. However, it could not be argued that excluding the evidence about a witness's past conduct might disadvantage the prosecution and impact the fairness of proceedings.
I think Article 6 ensures fairness for both parties. However, as seen in R versus Y and Al-Khawaja, I believe, excluding prejudicial evidence does not disadvantage the prosecution if credibility can be assessed through other means, like cross-examination.